You see flashing lights behind you, and instantly your heart drops. Another ticket means fines, points on your license, and skyrocketing insurance. But what if I told you there is a fully legal, lawyer-approved way to never pay another traffic ticket again? I'm Jeff Hampton, and in this video, I'm going to break down step by step the exact strategies so that the next time you're pulled over, you can avoid paying fines, you can keep your license, you can make sure that your insurance rates stay low, and you can avoid ever having to pay another traffic ticket again. The best way to avoid ever paying a ticket is to never get one at all. People sometimes forget this, but if you get pulled over by the police, your words and your behavior can make a huge difference as to whether the cop gives you an actual ticket or lets you off with a warning. So, before we get into the legal loopholes you can use to get out of your ticket, let's cover the exact strategies you should use when it comes to what you say to the police during your traffic stop. Number one, have your documents ready. I know this might sound obvious, but have your license, your registration, and your proof of insurance ready. That way, when the officer walks up, you can politely hand it to him. And if you're fumbling around and you start trying to figure out where all this is, the officer is going to actually raise suspicions about whether or not maybe you've had something to drink. Why are you so nervous? Maybe I need to get you out of your car. And it will not only keep you on the side of the road longer, the officer now doesn't really like you. And I know this is not a popularity contest, but if the officer starts feeling like you're not organized or in control, then now the officer starts thinking you're suspicious and you must be doing something wrong. Now, when I say have your documents ready, what I mean is have them in a place where you can easily locate them. Because one of the biggest mistakes I find people make is they get pulled over for a traffic stop and they start diving into their glove box, or they start reaching over into their center console or reaching into their pockets. And if you wait till the cop walks up to your front window to start doing these things, all of a sudden the officer is going to claim, oh no, my officer's safety is at risk. I think you might have a weapon. I think you're maybe trying to grab for drugs or something illegal here. So be careful. Have these documents ready from the very beginning. Now, I know this sounds like common sense and it's obvious, but the next point I want to make is, number two, do not confess to anything. One of the number one things I see people do is they get pulled over on the side of the road and they go, I know, officer, I'm sorry. And they start just saying things that could easily be construed as a confession to the officer. When you've been pulled over and you don't know what you did that was wrong, you can still be respectful and truthful, but you don't have to volunteer information. For example, if the officer pulls you over and walks up to your window and you were speeding, supposedly, one of the common things an officer will say is, hey, do you know how fast you were driving back there? Many people will immediately say, oh no, officer, was I speeding? I'm sorry, I didn't even realize that I was driving that fast. All of these statements can come across as confessions to the officer, so that even if he wasn't actually using the radar and he didn't have any proof of it, he can take the things that you're saying right there on the side of the road and use it as a basis to potentially establish proof of guilt. So instead, you can say, if the officer says, hey, do you know how fast you were driving back there? You can say, officer, no, I actually don't. It's my understanding I was driving the speed limit. What's going on? By laying it out there and still being respectful, being a human being, not acting like the officer is trying to destroy your day, because many people say, well, why do I care what the officer thinks? Do I have to really be kind and nice to the officer? One of the most important things that officers will tell you, the difference between whether or not they're going to write you a ticket or just let you off with a warning, is based upon whether someone is being respectful or whether or not they're being polite. So if the goal here is to never pay a traffic ticket again, and more importantly, never actually get the ticket when you get pulled over, make sure and remember here, don't confess to everything, but you can still be polite and respectful, so that way you may end up with just a warning. Oh, and by the way, please do not plead ignorance of the law as an excuse. One of the most common things I hear people try to do is on the side of the road, they'll say, officer, I had no idea that was against the law. As a general legal principle, ignorance of the law is not a defense. So many people will say, officer, I had no idea that was the speed limit on this road. The officer will actually take some of the things you say there and once again try to turn it into what seems like a confession. So don't plead ignorance of the law. Instead, don't admit to much of anything, be kind and respectful to the officer, and then that brings us to our next strategy here when you're on the side of the road. You may be able to actually politely ask for a warning. Now, this strategy can go both ways, and I'd love to hear what you think about this. But if you've established some rapport with this officer, let's say the officer is actually not aggressive, he comes to the front window, and he's actually being very kind, and he's asking questions in a way where maybe you think there's a chance there's some rapport that you have with them. You could politely ask for a warning, but be careful how you say it. And exactly the timing of what you do on this can make the difference between whether or not it's successful or the officer thinks you're trying to admit to something. Because remember the goal here. You do not want to admit to anything. You want to still be able to fight the ticket if you have to go to court later. But if you can establish some rapport with this officer, I personally have received dozens of warnings over the years, and very rarely did I actually receive a ticket by showing some kindness to the officer, but yet at the same time not admitting to anything. So if the officer, let's say he thought you were speeding, one of the things you could say is, "Officer, I really just was not aware of that at all. Is there any chance that I might be able to receive a warning? I'll make sure that I'm aware of any concerns about this in the future." Now, by asking for a warning, you've got to really read the officer. He may be on board with this, and he may consider it if he hasn't already written the ticket. But you don't want to admit, "Yes, officer, you know what? I was driving 20 miles an hour over the speed limit, but I haven't done it very many times. Is there any chance you could give me a warning here?" Because now you fully confess to it. But beware here. This is kind of a risky option because you need to be able to read the officer when he comes to your front window. And if it's all about the speeding and you've got a positive rapport with him and it seems like he's already leaning towards letting you go, this is an option that I've seen many drivers be able to use to avoid getting a ticket in the beginning. But what if you ask for a warning, the officer clearly says no, and now you get kind of frustrated with him because you weren't the only one speeding? Be careful. You could end up admitting guilt by excuse. Never say things, "Well, I shouldn't have to pay for this. I wasn't the only one out there speeding." If you say something like that, cops are only going to write down that you just admitted that you were speeding. And just because others were speeding will not get you out of the ticket. That being said, if you actually have a legitimate excuse, offer that excuse at that moment if it provides you a legal defense. For example, I've had clients where they were rushing someone to the hospital, to the emergency room. An officer actually tried to pull them over and actually gave them a ticket. Not believing that his wife was actually in labor, went ahead and gave the speeding ticket anyway, which I thought was crazy. But the reality of it is that can actually be a legal defense where if it's a necessity that individual, it's sometimes, and we'll break down the defense of necessity. Many times the law will say, if the need of the emergency in order to get to where you need to go outweighs the damage caused by breaking that law, then it's actually a legal defense. And finally, never bribe or threaten the officer during the traffic stop. I know this sounds obvious, but it's very important to understand. I've seen many people say, "Hey, listen, I give a lot to the police foundation. I've got proof of it right here if you'd like to see it. I really back the blue here and I care about you guys. Do you think you can cut me a break on this one?" Or you make an exchange. You offer an actual quid pro quo in order for the officer to let you go. Listen, most of the time these officers are running their body camera and the police dash cam is also on during this entire time. The officer is never going to fall for that. So the worst thing you could possibly do is try to bribe the officer, because by itself, that's a crime. And now you're going to have much bigger problems than just a speeding ticket. So consider these strategies and you may be able to escape a traffic ticket with just a warning. But what if you're not so lucky and now you're actually going to have to fight the traffic ticket in court? Let's break down the actual strategies you can use and the legal loopholes and technicalities that can make sure you don't ever have to pay a ticket again. Strategy number 1, leverage the no-show factor. Make it to where the officer or maybe a witness is not available for court. One of the simplest ways to get your traffic ticket dismissed is if your officer doesn't show up to the hearing. In traffic court, the citing officer is usually the state's only witness, and if that witness doesn't show up, then they don't actually have a case, and usually it ends up being dismissed. Think about it. The prosecutor can't just introduce police reports or other evidence without a witness. That's considered hearsay. So unless the officer is there on the witness stand, able to testify to exactly what you did, they actually don't have a case. On top of all of this, you also have a constitutional right to confront your accuser. You have the right to cross-examine that police officer to determine if he's being truthful so that the jury can know actually what's going on. If he doesn't show up, this is what we know as a Crawford violation. And because of this, it benefits you as the accused and your case could ultimately be thrown out. You say, "Okay, Jeff, fine, but how do I actually encourage a no-show?" Now, it's true that we can't force an officer's absence, but we can increase the odds of it happening. Trick number 1, delay your hearing. You have to understand, these particular hearings are usually set up where the officer is like a cattle call line, where the officer shows up where there's multiple citations that are set for that day, and that officer is expecting to deal with all of those citations on that court hearing. By postponing your court date, which is known as filing a motion for continuance, you may be able to continue the case to a different date where the officer was not scheduled in order to show up for court. Maybe they're scheduled for something else or they're on vacation, greatly increasing the probability they actually do not appear for court. The more you can separate your case from the officer's normal traffic court routine, the greater the probability that the officer just looks at it and says, it's not worth showing up just for this one case, or maybe the officer's busy doing something else. Trick number 2, opt for a trial by mail if available in your state. Some states offer you the opportunity to have a trial by what they call written declaration. It's also known as trial in absentia. For example, in California, both you and the officer can submit actual written statements and evidence by declaration. In other words, it can be mailed in and sent in to the court, and you don't actually have to appear in person. You say, Jeff, why would you want to do this? Don't you want the officer to not show up to an actual physical hearing? Well, here's where it works. So think of it this way. You get a chance to mail this in. Let's say you've mailed in your side, but the officer has a deadline to complete all of his paperwork, and if he misses that deadline, you win by default. So in California, as a good example of this, if you send this over, there may be thousands of citations that are out there, and the officer is primarily focused on showing up for those in person, but he may miss the deadline when it comes to his actual written discovery, or what is known as the written declaration. Now, here's the best part. Even if the officer does submit his written declaration of evidence and you lose in that trial, that written declaration trial, the great thing is you get a second bite at the apple. You can now request for what's known as a trial de novo, which means now you get to start all over and go to regular court and fight it again. Essentially, you get 2 chances to win your traffic ticket. So if your state offers this as an option, I encourage you, take advantage of it. It's a very powerful strategy where the officer gets kind of tired of dealing with it. I've already filled out the forms and information one time. I don't want to have to show up for this a second time. It can be extremely effective in winning your case. Getting your traffic ticket dismissed for an officer no-show is a great strategy, but remember, it's not guaranteed. If the officer does not show up for a good reason, let's say he's ill or he has an emergency, many judges could still grant what's known as a motion for continuance from the prosecution side, and you may still have to show back up. And in fact, some states are even starting to figure this out. One state being North Carolina. North Carolina, basically judges can decide on their own to allow for a reset of the case if the officer didn't show up, if they think it was for good cause. But the good news for all of us is that these traffic ticket dockets are so big that judges can't just reset all of these cases. So if you show up and you fight and use these strategies here, if the officer fails to show up in court, you have a great opportunity to get your case dismissed. Which brings us to our next strategy: demanding the evidence to beat your ticket. This strategy is very effective because if the government fails to give you the evidence you have a right to, or if the evidence doesn't line up with what the cop originally said, your case could be dismissed. 2 major areas to target here are police equipment and police records. For example, if you were stopped for a speeding violation, a very effective way to get your speeding ticket dismissed is to request both the calibration and the maintenance records of the radar guns or the LiDAR gun. So here's the legal trick you can use to give yourself the advantage. You should request the device's calibration logs, certification, and maintenance records through a discovery request with the court. If that officer or agency does not produce up-to-date calibration certificates, you can argue that the speed reading was unreliable and it now may be inadmissible in court. For example, in Ohio, the courts have ruled that if the prosecutor cannot prove the reliability of that radar gun, it's inadmissible in court, and without the radar gun, there's no proof of your speeding, you win your case. As another example, Florida law is even more strict. Under their law, it says specifically that in order for an officer to use a radar or laser reading against you in court, they must provide records indicating that it was tested for accuracy before and after each officer's shift and undergo certified lab calibration at least every 6 months. And another important part is officers must be able to prove that they've been certified and trained on the devices in order for it to be used against you. Think about this for a minute. If any of these conditions are not met under this state law, then the actual result of them using this radar gun against you is inadmissible in court, and now they don't have a case. So if your state has a law like Florida's, this is exactly what I would ask for under my discovery request with the court. The first thing I would ask for is I would ask for the make and the model of the unit, the last calibration date, the officer's training certificate on that particular make and model, and the proof of the shift tests that were conducted between each shift. But here's a key point. Always ask for proof of the device's accuracy. If the cops can't provide proof of the accuracy of their own radar gun, there's a very strong probability that either number one, the cops won't even show up to court when you ask for all this stuff, or number two, the judge will completely throw it out because they didn't meet the state's laws. Headlines are shouting at you from every direction. Bias, censorship, outrage. It's overwhelming. So how do you cut through the noise and find out what's really going on? That's where ground news makes a difference. Ground news gives you the freedom to discover for yourself whether what you are reading is unbiased and fair, so that you can come to your own conclusions. Isn't that what the news is supposed to be about? Check them out for yourself at groundnews.com/Hampton. Let's take the recent news story that John Cornyn revealed the FBI has agreed to both locate and arrest Texas Democrats who left the state this month to block voting on redistricting legislation. As we analyze the coverage in Ground News, the top right displays key details, the number of sources reporting, their political bias breakdown, reliability ratings, and ownership info. These insights show how outlets across the spectrum are framing the same event differently. One of the most powerful features of Ground News is the headline comparison, where we can see for ourselves how different news outlets are framing the story. By clicking on the left, center, and right, we can observe the language and tone used, allowing us to draw our own conclusions. For instance, a left-leaning headline might focus on threats to democratic norms, while a right-leaning headline might emphasize enforcing the law. But my favorite feature is the blind spot feed. With blind spot, you can see news stories that are disproportionately being covered by one side of the political spectrum. In our polarized environment, I have found this feature to be an amazing way to discover stories I would have never seen because only one side is talking about them. It's also perfect for better understanding friends and family who think and see things differently. The best part? Ground News has a special offer for my viewers. If you sign up through my link, you'll get an amazing 40% off the Vantage plan, the same plan I use to get unlimited access to all features. Go to ground.news/Hampton to give it a try for yourself. Click the link down in the description or scan the QR code to stay better informed and transform how you read the news. Okay, so now you have all the calibration and maintenance records, but what about all the officers' notes and reports? Most officers will jot down notes about the incident, and you have a right to those notes. But if they didn't write down any notes at all, it's even more helpful because officers do thousands of traffic stops all the time. And let's say you don't show up to court for months down the road, there's a good chance this officer may not remember anything about what actually happened. If the officer did jot down notes about what actually happened, this is key for you to review so that you can find inconsistencies and mistakes. For example, I've looked at cops' notes and I've seen them write down a different car or even a different location of the so-called incident, and they did it all by mistake because they were in a rush and they really didn't care about the ticket. And don't forget to always know your state laws, because in some states, like New York, you can also pull out another trick here and request the officer to provide what's known as a supporting deposition. This is a sworn statement from a police officer detailing the specific facts of what happened during your traffic stop. In New York, if you make a timely request for a supporting deposition and the cop fails to get it to you in time, this alone can be grounds for you to have your entire ticket thrown out in court. So look for these specific little hacks that you can use based on your state law. So if in New York, I would do this on every one that I ever got. If I ever got a traffic ticket, I'm going to ask for a supporting deposition because many of these officers are going to be too busy or just not put in the work to actually write it down. But remember, in order to take advantage of these techniques, you've got to make sure you make your written request for discovery well before trial, according to the timeframes provided on your citation. Personally, I would send requests by certified mail and keep copies. The government has a tendency to claim they never received your request, but if you use certified mail, you can show you followed all of the requirements. If you file your motion for discovery and the state continues to ignore you, you can now use what's called a motion to compel discovery, where now you can get an audience with the judge demanding that the state actually give you what you have a right to under the Constitution. And pro tip here, if the prosecution just completely ignores you and never provides you any of the evidence you legally requested, you can also make a demand to the judge to have the case dismissed because of a discovery violation. Now, courts don't always grant this, but if the evidence that the prosecutor and the cop were keeping from you was what we call material, like let's say it's a radar certificate, or maybe it's calibration records that would show it wasn't in compliance, I've seen many fair judges look over at that prosecutor and say, no, we're not playing this game. You're not clogging up my docket and not following the rules. I'm throwing out the case. But even if the judge doesn't throw out your case for failure to follow those discovery rules by the cops, you can make an argument that that evidence that was not provided to you should now be inadmissible in trial. For example, I've said this exact phrase in front of a judge before, making an argument why a particular radar reading should not be admissible in court. I said, quote, "Your Honor, I requested the radar's calibration records and none were provided, which suggests that they may not exist or are not current. Without proof that this radar was accurate, how are we to trust the reading itself? Your Honor, I would request that this evidence no longer be admissible." The judge ruled in my favor because the judge understands that we all have a right to confrontation. And if the state doesn't provide you certain discovery that you made the request to, now how are you going to actually fight your case if they're not playing fair? So remember, even if the judge doesn't throw it out, they may exclude the evidence from being used against you in court. And now you end up winning either way, because without a good radar gun, let me tell you right now, if they don't have a radar reading, they're going to have a hard time proving your speeding violation. So now that we know discovery requests can be used to get our traffic ticket dismissed, what about the legal loopholes and the actual technicalities that we can also use to make sure we win our case? Technicality number one, look for clerical errors on the ticket. Now let me start by saying that mistakes on a ticket, if they're not material, like maybe a misspelled name or maybe the statute was wrongly listed on the ticket, it doesn't mean those mistakes automatically void the ticket. However, if the error is significant enough where it could mislead you or change the nature of the charge, this can be a way to get your case thrown out. So here's the test that courts will use. They're looking to see, is it a clerical error or is it a fundamental error? Clerical errors can be easily remedied. Fundamental errors, it actually changes the nature of the charge and now there's no case. For example, in Ohio, a citation that listed the wrong code section but did list the correct offense was allowed to be amended in court. The court in Ohio actually laid out a test for us to use. And the test was this: was the driver given clear notice of the actual charge? And were they misled or disadvantaged in preparing a defense? On the other hand, if the ticket lists a completely different offense, let's say the officer claimed he pulled you over for speeding, but then he actually wrote down that you ran a stop sign. This could actually fundamentally change the entire nature of the charge itself, and it would put you at a disadvantage in preparing for your defense. That type of error should almost always result in a dismissal of your charge. Always review your ticket for accuracy. Because if the officer wrote down something that seems to be fundamentally different than than what he actually claimed to pull you over for, the worst thing you could possibly do is point out the error to the cop on the side of the road. I've seen people do this before where they're like, "Oh, officer, you wrote this down wrong. You can't charge me for this." The officer goes, "Oh, well, give me the ticket back." And he literally writes them another ticket right there and fixes the error. Save it for court. Allow the officer to make the mistake and use it to your advantage to potentially show that it was a substantive error and the case should be dismissed. Once you've thoroughly gone through your ticket and you've looked for clerical errors to establish a loophole for dismissal, then we want to start looking at your state's unique quirks. What laws exist in your state that can give you an advantage to surprise the officer and get your case dismissed? Each state has unique laws that clever drivers can exploit, so it's important to know your state's unique laws. If you remember, we covered that Ohio requires scientific reliability proof for a radar test to be used against you in court. We also covered that Florida has very strict radar evidence rules you can use to get your speeding ticket thrown out. New York also provides this support deposition strategy that you can use in order to overwhelm an officer with paperwork requirements to get your case dismissed. And we covered California's trial by mail option, where you can actually get 2 bites at the apple to win your ticket case. Another example would be Texas. Texas has a unique loophole when it comes to speeding tickets. Texas treats speed limits as what they call prima facie limits. Now, what exactly does that mean? Legally, this means if you exceeded the posted speed limit, then it is presumed that you violated the reasonable and prudent speed allowed under the law. But you can rebut that presumption by proving that your speed was safe under the conditions. So how does this exactly work? Let's pretend like a Texas driver was driving 10 miles per hour over the speed limit. And as they were driving, it was a clear day on a wide highway and they were keeping up with the traffic flow. Essentially, that their speed wasn't actually unsafe. Now, 10 miles an hour over the speed limit might be a tough sell, but let's say you're in the 5 to 7 mile an hour range and you're following the flow of traffic, it's a clear day and you're doing everything everyone else was. You can actually potentially rebut that prima facie argument that state law provides in Texas. Similarly, check your state laws, because if cops are running speed traps, those areas in many states are required to be certified, or there can be areas on highways where using radar guns or LiDAR is prohibited. And I've found many times where officers will just completely disregard those and they will use the radar or LiDAR guns wherever they want. And finally, if all these legal loopholes and technicalities don't get your traffic ticket dismissed, you can still win your traffic ticket case by challenging the officer's testimony and what he claimed he observed. So let's say the cop does show up to court. Now you're there. Jury selection begins. The officer is now called by the state to get up there and testify about what happened. Now it's important to know, where was the officer located when he claimed you committed this so-called traffic violation, and what was his perspective on what he actually saw? And remember, one of the best ways to challenge the officer is if he didn't write down any notes. He can many times say, I don't remember, I don't recall, it's been so long ago, I don't remember, I have thousands of traffic stops that I do. Remember, you don't have the burden to prove anything. The state has the burden to prove even a traffic violation beyond a reasonable doubt. Okay, it's really important to understand that if they're trying to make you pay a citation here, the more the officer doesn't remember, the more unreliable his testimony is. For example, let's say an officer did not have a clear line of sight or was not fully paying attention. I see this happen a lot when an officer drives by someone in a split second. Let's say you're driving this direction and the officer's driving head on in your direction and you just passed. In a split second, the officer didn't really observe much. And you can introduce doubt about what all these conclusions he came to just by driving by you. If you were driving 60 and he was driving 60, there's no way he caught much of anything going on because of the speed and the instant moment of what he saw. Another great tactic to use is, I know a lot of prosecutors will only quickly get the basic facts out of the officer and not really get into the details. Just say, okay, officer, you saw him doing X and Y. That sounds good. Lines up with the citation. No further questions. Make the officer remember, make him recall where he was in relation to where you were. A great example of this, I've seen officers where they're either behind 2 or 3 cars. Let's say they're behind you by 2 or 3 cars and they see you supposedly do something, but their vision is impeded by 2 or 3 cars between you and them. Or maybe they see you through their rear view mirror and there's a car separating between the two of you. That kind of information is very important. Many jurors and judges will look at that and say, now, this officer was just going off of a hunch and he didn't really see much and there was not much here to really rely upon. And by all means, point out all the faulty notes and the bad memory of the officer, because he's dealing with so many cases. Many times he gets them mixed up and he fails to really write down information. For example, I had a case one time where the officer was claiming that this happened at night and so that it was dark outside, but it was in the summer and his notes on the actual citation said 5:45 p.m. And one of the things I asked him, I said, officer, you wrote down that it was 5:45 p.m., but you said it was dark. This happened in July. Is it possible you're getting your cases mixed up here? And the officer kind of just was befuddled by it, didn't know really what to say. And said, I don't know. I deal with a lot of these. And you could see the look on the judge's face. You could see the look on the actual prosecutor's face and the jury's face, where now if we can't believe him or we're not sure about the small details of the case, how can we begin to believe him about the major issues involving convicting someone of this citation? And finally, if, for instance, let's say that you get the radar gun thrown out during your speeding ticket trial, and now the officer wants to claim he was pacing you, and he could tell by visual observation how fast you were driving, it's important to get into their training and experience about how an officer could actually come to that conclusion. For example, you could say, quote, officer, you estimated my speed by eye at 70 miles per hour. What training have you had in visually estimating vehicle speed? Many times officers will just say, well, that's just my experience. I've been doing this for 10 years and I've seen lots of people driving down the road. Well, so has everybody else. And then you could follow up with this question, quote, have you been tested or certified in visual speed estimation? Of course, the officer is going to say no. Then you ask the ultimate question. So is it possible, officer, that your speed estimation could be off? Is it possible that you could be mistaken here? I love to ask that question because when an officer says, no, it's impossible, there's no way that I could ever be mistaken, the jury and the judge doesn't believe them, right? Everybody makes mistakes. But if the officer admits, I guess it is possible that I could have been mistaken here, and maybe he was driving the speed limit because I was visually estimating it, now there's reasonable doubt for you to win your case. This is important because some states, like Ohio, ban convictions for speeding based on visual estimates alone. Finally, raise your legal defenses during the cross-examination of the cop. Make him specifically answer whether or not he believes it's reasonable. For example, I've actually questioned officers about the necessity defense, where someone's in a rush to take someone on a medical emergency to somewhere, or maybe there's someone that they believe is in labor, about to have a child, about to have a baby. And I've had officers actually say, well, yes, they did technically violate the law. They were speeding. They did do something improper. They did run that red light. And I'll ask the officer, but would you agree with me that it might be justified here to prevent the greater harm of the childbirth taking place in the car, or maybe someone having a medical emergency and dying? Couple that with hospital intake papers and maybe you actually testifying that you get up there and admit the only reason I did this was for this purpose. It actually shifts the burden back onto the state to prove that you didn't act with necessity. So it's an example of using this, and it's very important. Another example I'm going to show real quick is sometimes you maybe swerve outside of a lane. Maybe you cross a lane divider, which technically is a traffic violation, but you did so in order to avoid another person that you believe was about to run into you. These are just a few examples of affirmative defenses that you could use if it applies in your situation to win your case. But remember, at the end of the day, you emphasize the burden of proof. Officers tend to get lazy. They tend to not be detailed when it comes to citations, and you don't have to prove anything. The state must always prove the case beyond a reasonable doubt, and you have the burden in your favor, and it's important to remember that. So every hole that you can poke, every legal loophole you can provide, provides a way for you to not have to pay for another traffic ticket again. So there you have it. A playbook of loopholes and strategies to help make sure you don't have to pay for a traffic ticket again. But what if instead of paying for a traffic ticket, what if there's a way to never get pulled over again? Did you know that there are strategies, legal techniques, as well as driving techniques that you can use in order to avoid ever being pulled over at all by the police? Check out this next video where I break down how to never get pulled over again. See you over there.